Okay, good afternoon, everyone. Welcome to Senate Education, 1:30 on Tuesday, April 4th. We're being joined by our House colleagues. I asked Ms. St. James to put together an explanation and some background information on, I believe it's pronounced Vital, but I could be mispronouncing it.
I don't remember.
Vital and others versus Bellows Falls Union High School and others. And this was a court case that came out recently. Many people may have seen it in the press. And it seems to have, according to the press, it's hard to really understand whether or not they're opening the door to more choice or if they're closing the door to choice or what they're doing in the state of Vermont. And since we're about to jump into some of these independent school related issues that are connected to school choice, I thought we could just understand this recent state Supreme Court decision. And so with that, the floor is yours, Ms. St. James, and I will ask Hayden, if he doesn't mind, if there are questions coming from the House, good ones, we'll have them answer. Please. Okay. Ms. St. James.
Thank you. Beth St. James, Office of Legislative Counsel. So I threw together a slide deck for you. You all have it.
We do.
Do you want me to share my screen or just talk, assuming that everyone has it?
It's the committee.
Does the House have a copy?
They should.
My recommendation is share so that if someone else is viewing.
It's also,
Oh, yeah,
it's
good
also
idea.
posted on your website. But
Okay. Yeah, if you would share it, that would be great. I sent you the Zoom link for that.
Yep.
Sure.
State House.
Oh,
Yeah.
it's just,
Yeah.
Always get split down a little.
are we ready? Okay. So first slide is just the title slide. We're going to move on right to slide 2. So I just want to start by saying this is a Vermont Supreme Court case. Oral arguments were heard, I believe, the very beginning, actually, I think the very end of last November. And the Supreme Court issued its written decision a couple weeks ago in March. You can find the actual decision of the court on the court's website. And this slide deck by no means contains every salient fact or argument or point. We have a half hour today, 25 minutes at this point.
Well, we can go longer depending on your schedule.
I've got another minute too. But just so that you all know, there's more, especially if you're a lawyer and you are going to nerd out on judicial review and the levels of judicial review and types of analysis here. There's more to this case. So this is meant for this audience to just orient you to the conversations you all have been having around the Tom Tuition Program and what was decided by the Supreme Court in this case. So starting with some orienting facts here, we're going to look at who the parties were, what were the facts of the underlying case, and kind of what was the main claim that the plaintiffs are trying to make then how did this come before the Vermont Supreme Court? So the plaintiffs in this case were three Vermont families with school-aged children, and the defendants were, at the time of appeal, the state of Vermont, the Secretary of Education, the State Board of Education. Initially, the school districts that all of these families resided in were also defendants, but they were dismissed out of the case, which is why it's confusing. Bellows Falls is the defendant. It was the first one listed, but they were no longer defendant in this case. So the facts, and there aren't a lot of facts to talk about here, and that will become more clear in a second, but it was three families who all resided in school districts that maintained a school for at least some grades. So no tuitioning options. And the families all preferred that their children attend a school other than the public school available to them in their district of residence. And they reported the following as some of the reasons for this preference. So some of the children had experienced bullying and harassment. Some of them claimed that they had experienced a disparate treatment by school officials, and some of them claimed that services within the district of residence were not adequate. And the families wanted their children to attend schools that best fit the needs of their particular child at the state's expense. The Supreme Court didn't get to flush any of those arguments out because the way that this case came to the Supreme Court was on a motion to dismiss. So at the trial level, right? So I want to sue someone. I'm the plaintiff. I'm the families in this case are the plaintiffs. I file a complaint, and the defendants come and they have to file an answer. They also have the opportunity to say, wait a minute, what you are alleging here is in a very simplistic way to put it, is either there's no basis for that in the law, or you haven't met kind of your initial burden to state a claim that there is relief available for. And so we're not going to have witnesses. We're not going to exchange discovery. We're going to ask the court to just dismiss this case outright. And that's what happened here. And the lower court, the trial court said, state defendants, we agree with you. So the lower court dismissed the plaintiff's complaints for failure to state a claim upon which relief could be granted. And what they were arguing below was that the lack of school choice for families not living in tuition districts violates the education and common benefits clauses of the Vermont Constitution. And so the lower court said, your complaint did not state a claim upon which relief could be granted. We're going to dismiss the case. And then the families appealed to the Supreme Court. So the Supreme Court did not have an opportunity in this case to flesh out those facts with the bullying, harassment, the disparate treatment, school officials, all of that. That's not what they were looking at. They were just looking at whether the lower court should have dismissed the case. Spoiler alert, they agreed with the lower court. So this case has been dismissed. It's not going anywhere. So just want to point this out because I think this is an interesting wrinkle here. And when you are alleging, if you are challenging a law as unconstitutional, there's kind of two categories that you can challenge under. One is a facial challenge, and you would be asking to invalidate a law as it's written on its face. It's a challenge to the way the law is written on its face. And a facial challenge would apply to everyone. You're saying there's no possibility, there's no scenario under which this law would not be unconstitutional.
Give us an example.
Oh gosh. I will in here.
Okay.
And then the other category is an as-applied challenge. And that's when you're saying, this law, as it's applied to me in my situation, is unconstitutional. And in that case, the remedy that you get is going to be limited to you and the facts of your case and the remedy available to you. It's not going to be a broad application to everyone. So in a facial challenge, if someone wins on a facial challenge, arguing that the law is unconstitutional as applied to everyone on the face of the law, then the law is unconstitutional for everyone. But on an as applied challenge, right? It's right there in its name. It's just, is the application of that law to you unconstitutional or invalid? On a facial challenge, all you have to wait for is the governor's signature. As soon as that law is law, anyone can bring a facial challenge. On an as-applied challenge, you have to wait for the government to actually take action. There has to be an application of the law. Also, you have to exhaust your other remedies before you get to this as-applied challenge.
I no longer need an example.
Okay,
If anyone
well,
else does, that's
okay.
very helpful. Yeah.
So what happened here is there was some confusion, concern, disagreement between the parties on what the plaintiffs were actually doing here. Did they have were they making a facial challenge, or were they making an as-applied challenge? And the reason that there's some discussion of that here, which I think is important to kind of think about in the back of your minds, is that on those facts, right, some of the allegations they were making is that there was bullying and harassment that maybe wasn't resolved appropriately in the public school system. But they hadn't gone through the process of state law to remedy those issues.
The defendants and
The plaintiffs. So you can file a complaint under the state's bullying and hazing and harassment laws that there has been bullying or harassment or hazing behavior, and there's a whole process in state law in Title 16 in your green books for what happens to that complaint process. And so some of these, not all, but some of these allegations that the families are making, saying tuition would be better for us because of all of these issues with the public schools in our area, they hadn't sought any of the remedies available to them for those particular issues.
They just came and said, this
They
is
just
the
came and-
problem. They
exactly.
didn't- Okay, got it.
In some areas, there may have been some exploration of those processes, but they weren't exhaustive. And so it really prevented them from raising an as-applied challenge. And the as-applied, remember, is to their position only. So what they were faced with is go back and start all over and do all those remedies and maybe bring this case again. Maybe there's a whole other legal doctrines out there that might come into play if they do that. Or they can say, no, we're raising a facial challenge. We are saying that as applied, this law, there's no way that this law could be constitutional no matter who it's applied to.
And have they done that?
That was their
That is
argument
the
here.
fair- that's the facial.
That's their
Okay.
argument
Thank you.
here. And
Okay.
that's what the lower court dismissed.
Okay.
And then there was the appeal to the Supreme Court. So I make this point to say that what these families were arguing here is not that tuitioning, it wasn't the fact that it was unconstitutional. The tuitioning setup system was not fair for them. It's that it wasn't fair for anyone. That there was no situation in any school district for any family under which the town tuitioning system was constitutional. And they will go on to see what those arguments were. So it wasn't just they were making an argument about how it worked for them, but it was an argument for the whole state. And that I think becomes important as we look into the arguments here.
So I'm asking a question then, how did all the bullying and harassment stuff come up? Did they just share that at some point?
We'll
see.
we'll
Okay.
see as we go on. So at this stage in the game, at a motion to dismiss stage, all you really have is the complaint. And so the complaint has to allege facts, and it has to allege, your legal arguments, if you will. And so within the complaints themselves, there were some allegations under of the bullying and harassment issues, the disparate treatment issues, the services issues. So those were all, there were some facts about those issues in the complaints. So what the court did here is it said, okay, we've got a facial challenge here to the town tuition system. And there's really kind of two types of claims that you're raising here, families. One is an equal educational opportunity claim. And that's going to involve the education clause and the common benefits clause of the Vermont Constitution. And this is basically an analysis under what the court in Brigham did. So if you'll remember Brigham, back in 1997, the state is responsible for providing substantially equal educational opportunities to Vermonters. It's what led to our current education funding system. But what's important to note here is that under Brigham, the Supreme Court was clear. The state has a fundamental obligation to provide Vermont students with substantially equal educational opportunities. And in arriving at that conclusion, they looked at the education clause of the Constitution and the common benefits clause of the Constitution. So the education clause is states a competent number of schools ought to be maintained in each town unless the General Assembly permits other provisions to the convenient instruction of youth. And then I've added another spoiler there. This is a line from this case. The Supreme Court eventually found that there's no right to attend the school of their parents' choice at the state's expense. And then the Common Benefits Clause says the government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, and not for the particular emolument or advantage of any single person, family, or set of persons who are part only of that community. So taken together, that's where the Supreme Court under Brigham said states responsible for substantially equal educational opportunities. So in this case, in Vitale, the court saying, okay, the first analysis that we're going to look at in your arguments here is we're going to do a Brigham analysis. We're going to look at it, your argument under the education clause and common benefits clause. But you're also kind of making this broader common benefits clause, like get the education clause out of the way. It doesn't matter that it's education. The common benefits clause in and of itself says that the tuition system is not fair because it's not available for all, right? And so under the common benefits clause claim, there's a case from 1999 called Baker v. State that has a three-part test for just a common benefits claim. So under the equal educational opportunity claim, this is the Brigham analysis, okay? The Supreme Court here is holding that Vermont children have a fundamental right to education under the education clause of the Vermont Constitution. In Brigham, they said it was the state's responsibility to provide that education, and now they are clearing up without a shadow of a doubt that if the government has a fundamental obligation to provide something, therefore, children have the fundamental right to receive that education. But the education clause does not say anything about how the state has to provide that education. And so school choice itself is not an educational opportunity, the court is saying. It's a means to provide for educational opportunities. So school choice is permitted, but it's not required under the educational clause. So the education clause says you have to provide substantially equal educational opportunities under Brigham. But it doesn't say how you have to provide that. That's really up for the legislature to decide. So previously, back in 1983, there had been a number of tuitioning cases that bubbled up through the starting back in the 60s. And in 1983, there was a case of a family who sent their child to a private school and tried to get reimbursed from the state. And the Vermont Supreme Court at that time said there is no constitutional right to be reimbursed by a public school district to attend a school chosen by a parent. So that has been floating around out there since 1983.
That sounds pretty clear.
Yep.
This family wasn't from a choice district. They just basically sent their kid and they expected to get reimbursed.
Yes.
Okay.
So remember, under Brigham, we've got two clauses to look at. So the education clause is saying it's just, the state's got to provide the education, but it doesn't, the Constitution doesn't say how. That's going to be up to the legislature to decide. What about the common benefits clause? Do the means selected by the legislature treat children unequally under the common benefits clause? It's kind of like the next step in the analysis. And so under the common benefits clause analysis, the plaintiffs must show that school choice, which is remember, it's a means to meet educational ends, not an educational opportunity itself. In order to survive a common benefits clause challenge, they've got to say, they've got to show that the means result in substantially different educational opportunities. But the parents didn't allege any of that. They didn't state facts to support that claim on their complaint.
Right.
So what the Supreme Court says is the parents' failure to allege facts to connect school choice with better educational opportunities is fatal to their claim.
So if I may,
Mhm.
just learning this also as I go here, behind the clock. If the parents had said St. Johnsbury Academy provides a better opportunity than I have in whatever non-choice town they have, that would have made their case stronger.
I don't know,
You don't know, okay.
because what the Supreme Court goes on to say is,
Again, it would have to be that St. Johnsbury is stronger and all the, or school A, school B, it doesn't have to be.
well, again, remember, it is in your scenario, are we talking about a facial challenge or an as applied challenge, right?
Right,
Because a
right.
facial challenge would be every kid in the state.
Yeah,
So what the Supreme Court said is they didn't allege any facts in their complaint to survive a motion to dismiss. And in a motion to dismiss, the court is kind of assuming that everything the plaintiffs are saying is true. We'll give you the benefit of the doubt here. If you can get over that hurdle, that we're going to assume everything is true, if taken at face value, if you can allege a claim, if you've stated facts on which you can support your claim, then we'll move on to the trial process. But what the Supreme Court says is here is they didn't allege enough in their complaint to state that, let's see. So what the Supreme Court says is it's not reasonable to infer from the experiences of 8 children that there is a factual link between town tuitioning and educational outcomes for all. And even if you could, it's unreasonable to infer that it's substantially unequal. So the differences in the availability of choice alone do not constitute the substantial inequality of educational opportunity. Okay, so that's the Brigham analysis. So dead in the water, your complaint doesn't allege enough facts to get us to that substantially unequal educational opportunity.
it's a great explanation, but
Next analysis is, okay, the Brigham analysis is really specific to education, but the common benefits clause applies to all government benefits, all government services. So what about a non-educational common benefits claims? So in the Baker case, the common benefits clause analysis has a 3-part test. So the complaint itself, remember, the complaint on its face has to allege facts sufficient to define the part of the community disadvantaged by the legal requirement, identify the governmental purpose, if any is known, and excluding a part of the community from the benefit, and state how the omission of a part of the community from the benefit does not bear a reasonable and just relation to the governmental purpose identified. So remember, they're saying that it's not fair that all children don't have school choice. And so, because the common benefits clause says we provide, government services are for all. And so in order to survive a common benefits clause analysis, the complaint has to allege facts that would apply to those three points. So for the first 2 there, the defining the part of the community and the government purpose, the court made some assumptions. It didn't say that they had met those burdens, But for the purposes of advancing the analysis, the court says, okay, we're gonna assume, without actually deciding or holding so, that you've met the first two parts here. So what that third part, the court held, the complaint contains very little to discern how the statutes are unreasonable or unfair in light of the government's stated purpose to provide quality education while adapting to local needs and desires. Again, they didn't allege facts in their complaint to survive, to prove this test on its face. Is that clear to folks? So we use the, have you heard the term prima facie? Okay. That literally means on its face, right? And so for a complaint to survive, it has to make a prima facie case to survive a motion to dismiss at this stage. So it has to articulate how the statute is unconstitutional under the applicable standard, substantive standard. And so the applicable substantive standard here is this 3-pronged test. And the court is saying, you didn't give us enough facts to make a facial case under this test. So ultimately, the court found that the complaint fails to make out a prima facie case, remember on its face, under the standards articulated in those should be italicized, Brigham 1 and Baker, those are cases. We accordingly conclude that parents have failed to state a claim for an equal educational opportunity or other common benefits violation. It's all, I'm going to ask you to ignore everything under black for a second. All this court is saying is, your complaint was not good enough to survive a motion to dismiss. So you're done. But, and this what I'm about to read next is again a quotation from this case. I don't think it necessarily needed to be stated. This is kind of an obvious one, but I think it's important. So our conclusion in this case does not end the evolution of the debate over how the state should educate Vermont children. It does not foreclose the possibility that a plaintiff could bring a challenge that satisfies the legal standards stated in this opinion. When we review legal questions, we are limited to the controversy before us. So that last line, that's a no-brainer. When a case is before a court, they are not out there making assumptions or trying to look at things outside of the record, and the record is going to be different depending on the procedural posture of a case. In this case, the record before the Supreme Court was just the complaint and the motion to dismiss. And there may have been some other things, but for the purposes of this conversation, that's really what's important. So that's what they were limited to here. So this case does not stand for the fact that town tuition program as it stands in state law is constitutional forever until the legislature makes a change. It just, what was provided in this case failed to even make it to the trial level because it failed to make a facial prima facie case under the applicable substantive legal tests that they had to survive.
Senator Rashid.
Quick question, was it dismissed with or without prejudice?
Oh, I don't know.
Would you tell us a little bit about that question?
One prohibits issue or claim preclusion, like you can't bring it back, and the
Okay.
other does not prohibit that.
Thank you.
And so were they trying to show that the lack of opportunity was the injury?
We don't know what they were trying to show because they didn't show anything. That's basically what the court is saying. Is and that's why I started by saying there's lots more in this opinion. But yes, there was some. They tried to develop some of these claims outside of their complaint by citing to some studies, et cetera. But they couldn't do that because it wasn't in their complaint. And on a motion to dismiss, that's what the court is limited to looking at. But yeah, I mean, theoretically, this court is saying well, they didn't do it here, but that doesn't mean that another family or anyone with standing could make a claim that asks us to make these decisions, that gets all the way to the heart of what these families are trying to argue. And that's that the town tuition program is unconstitutional because it's not a benefit for all.
Are the dismissal reviews reviewed by the entire court, or like one or two justices?
This was heard by the whole bench, the whole Supreme Court.
And in this kind of case, is there an opportunity for dissent? Is there a dissenting opinion?
There isn't in this.
Okay. Is there a vote count?
I'm just looking at the written opinion, and I don't, there's no dissent and there's no vote count. It just says we affirm.
Right.
And I'm trying to think of the cases that I've had in front of the Supreme Court, and I think they were all unanimous decisions, so.
So this US Supreme Court decision I've heard mentioned, does that affect this?
Are you talking about Carson v. Macon? No.
Back to Senator Hashim's question about whether or not that you can return to the court for this. There's no reason there's nothing saying that you could not.
There's lots of legal doctrines. So it would depend.
Okay.
I don't want to get out too far in front of my skis here.
Yeah.
There's lots of reasons why they could, these families may be precluded in the future, but I'm not going to state that they are precluded in the future. But certainly there are many families that are similarly situated to them.
Representative Conlon, do you have questions, or does your committee members have questions?
I'm not seeing any, and also we're going to sign off because we have got some 2:00 testimony scheduled, and we really appreciate you sharing the testimony with us. Thank you.
Thank you. Thanks for joining us. Good to see you. Senator Hashim.
It's waving goodbye. Thank you for your time.
Anything else for Ms. St. James? It's a great presentation. Yes, Senator Jones.
It's more of a comment than a question. I've showed my legal ignorance in this committee many times, but it does seem as though if courts signal it seems as though what they're signaling here is if someone were to do this again and do it right, we would take it up potentially.
I don't know that I feel comfortable agreeing with that.
Okay.
The way you stated it, but certainly what the court is saying is these plaintiffs have failed. But if other plaintiffs state a claim that would get past a motion to dismiss, they state a claim on which relief is available. So they are looking at the Brigham analysis and they're stating facts and making arguments that would satisfy the Brigham test. And then they look at the more general common benefits clause case. They're stating facts that would prove those prongs and making arguments that would prove those prongs. That would get them over the motion to dismiss hurdle. Then they would have trial. And so trial then results in either a negotiated settlement. And we saw this in the tuition cases that were in the federal court system this summer, where there were negotiated resolutions related to whether school districts were required to allow tuitioning money to go to certain schools. Those negotiated resolutions were applicable only to those school districts, not the state. So even if you get to that trial level, it's possible that in most cases settle, no matter what they are. Criminal cases, civil cases, administrative cases, most cases settle. So if you get to that trial phase, the odds of a settlement are good. What does that settlement look like? Is it just for those families? Is it just for those school districts? Is it just for certain situations? Or is it going to be a broader application? It's unlikely to be a broader application, even though that's possible. And if you go to a trial, then what does the trial court decide? If the trial court sides with the plaintiffs, again, was it an as-applied challenge or was it a facial challenge, right? Is it holding that? So there's multiple levels before it would get to the Supreme Court, but if it did get to the Supreme Court, it could require the Supreme Court to make a determination of whether it was an as-applied challenge or a facial challenge. The tuition program is constitutional under the Vermont Constitution, so it could rise to that level, absolutely.
And one of the reasons I asked St. James Inn is we're taking a look at H43 on Thursday. We have Representative Conlon taking us through, that is this House's independent school bill. And just so that we sort of team that up a little bit and just have as much background information on what's happening out there in the legal landscape as possible. And we should have, if we don't already, Miss St. James Inn at the same time. Anything else? Thanks, sorry we kept you over.
But all right.
We're so helpful.
It was a great presentation.
So for now, nothing's changed.
Right. And, perhaps the question either, would be, I mean, is there anything for us to keep in mind as we work on our bill? I think it's just good to know that this is out there, but like you said, nothing has changed. Well, certain messages may have been sent, but nothing's really changed.
No, I mean, I do think the holding that the Supreme Court made here in that children have the fundamental right to education, right? Before the holding of Brigham was the state has a fundamental obligation to provide education. And now the Supreme Court is just clearing up any confusion and saying, yeah, the state's got to provide it. Someone has to receive it. So we're gonna finally state once and for all that children actually have a fundamental right to receive education in Vermont. And it's the state's responsibility.
What is that really? How does that really change things? If you could help me with that. And this is a layperson's,
I don't know that it necessarily changes anything, but I think it makes it more clear that there are rights to be asserted versus an obligation on the state to provide something. But the Supreme Court has not had to weigh in on what does substantially equal educational opportunities mean. So that's the fundamental question at play here.
Your Honor, any questions?
No.
Great. Thanks, Ms. James.
Okay.
Okay. I just, quick 5-minute break.